Hearing the matters of Haworth and others and HMRC part heard.
Yes, Mr. Stone.
My Lord, first I'm going to deal with a couple of points of housekeeping.
Yes.
You asked the appellants yesterday to produce Swedish Railway and Bulock.
Yes.
And they've helpfully produced those and have put them in the back of what was your supplementary authorities bundle with the assistance of those behind you, my Lord. So there should be 3 further tabs in that bundle. And they also produced a case of Egypt Delta, which was also referred to in Bulock.
Yes.
I'll return to those in due course, if I may, just to state what is now agreed on the other side in answer to my Lord Justice Arnold's question. It's accepted that Swedish Railway is authority for the proposition that there can be 2 places of central management and control, and that is binding on the court, as explained in Bulock. I'll come on to look at Bulock in due course.
Right. That was one matter of housekeeping. Was that
There is, I'm afraid, a further
Yes.
folder of 3 cases and 1 bit of the OECD commentary, which we've handed up, which we intend to rely on in answer to some of the points made yesterday by my learned friend. I would just ask you to note that for now, and I'll come to those authorities in due course.
Thank you. Thank you.
So, my Lord, in terms of the structure of the submissions today, as I indicated yesterday, we say that there are 2 routes to deciding the appeal in HMRC's favour. One is to follow what the Upper Tribunal did, which is to decide that Smallwood is binding authority on POEM, that the FTT, in our case, followed Smallwood, and there was therefore no error of law in doing so. So I'll turn first to look at Smallwood and what it decided, and then secondly I'll look at the sort of approaching the question from the point of view of first principles, looking at treaty interpretation and the guidance we have on that,
Yes.
and reaching the same conclusion, which is that the test applied by the FTT was certainly one that was open to it, and that the test proposed by my learned friends at paragraph 36 of their skeleton is not one that you would get if you approached it from first principles.
Yes. Good.
So, if I may, my Lord, then to what Smallwood decided. Before diving into the detail of the case, I would, if you permit me, give you some overview, just so we don't lose the narrative of what was decided at the relevant stages in that case. So before the Special Commissioners, this taxpayer submitted that the tests of CMC and POEM were for practical purposes the same, and submitted that POEM should be determined in accordance with Wood and Holden. We see that the Special Commissioners expressly rejected CMC as being the relevant test for determining POEM. Instead, they applied a test based on what they considered to be the ordinary meaning of the words of Article 4.3. The earlier decision of the Special Commissioners in Wensleydale, and to some extent the 2000 commentary. Having rejected a test based on Wood and Holden, the Special Commissioners did not make any findings of usurpation. In the High Court, as we know, matters were decided differently in the introduction of the snapshot argument, so we don't need to worry about the High Court decision for present purposes. In the Court of Appeal, it was common ground that POEM was to be interpreted in accordance with the test set out in the 2000 commentary. So there was unanimous endorsement, if you like, of that as the overarching test, and that is the place where the key management and commercial decisions that are necessary for the conduct of the entity's business are in substance made. However, this is a crucial point, there was disagreement between the parties and therefore between the minority and the majority as to the proper approach to apply that test. To expand that further, Mr. Prosser for the taxpayer said that it was necessary to apply a test derived from Wood and Holden, and he submitted that because the specials did not make any finding of usurpation, it was not open to them to find the POEM was in the UK, i.e. they must have applied the wrong test. Lord Justice Patten agreed with Mr. Prosser that the correct test was derived from Wood and Holden. he agreed with him that the specials had not found usurpation, and he therefore would have allowed the appeal on the basis that it wasn't open to the specials to find poem in the UK. Lord Justice Hughes agreed with Lord Justice Patten that the findings of the specials did not go as far as finding that the functions of the trustees had been wholly usurped, but he disagreed with Lord Justice Patten that Wood and Holden was the relevant test. He found that the specials had addressed the correct questions and that on their findings of fact they were entitled to find poems in the UK. And as we know, Lord Justice Ward agreed with Lord Justice Hughes. So in my submission, my Lord, there was accordingly a difference between the majority and minority as to how the test of poems should be applied. And the majority finding that it did not require usurpation. And in my submission, if Lord Justice Hughes had considered that the proper test for poem was that derived from Wood and Holden, he would not have been able to uphold the decision of the Special Commissioners because, as was common ground, their findings did not go that far. Now, that summary of the cases is effectively one that you see accepted by the Upper Tribunal in the decision below. And in my submission, it also accords with Lady Rose's description of the Court of Appeal in the relevant passages in her judgment in the judicial review case. You saw part of those passages in oral submissions yesterday. My learned friend having said nothing about them in his skeleton argument. Now, yesterday, my learned friend's submissions to you were that the effect that the specials had rejected Wood and Holden and that they did not find usurpation. So, to that extent, he agreed with some of what I've just said. I find it surprising that those were his submissions because they are diametrically the opposite of what he said in the Upper Tribunal. And if I can just show you the passages from the judgment of the Upper Tribunal to make that good, if we could turn please to the core bundle at page 80. Sorry, 82. And if you have paragraph 80 of the Upper Tribunal's decision.
Yep.
Sorry, just give my Lord Arnold a
Sorry.
chance to turn.
Sorry.
You see paragraph 80. Mr. Ribbett argued that the Special Commissioners applied the test in Wood and Holden and found that the decision-making function of the trustees had been usurped, although they did not use that word. He says that the majority of the Court of Appeal did nothing more than find the specials as being entitled to make that finding on the facts. And then if we go down to paragraph 96, please, which you find on page 87. Paragraph 96 starts, Mr. Ribbett submitted, and then it says, third sentence, the fact that the Special Commissioners endorsed a test which involved looking at the decisions of the trustee as trustee indicates that it was not rejecting the approach in Wood and Holden. And then, if I could take you please to paragraph 110, which you find on page 90. The Upper Tribunal say, we respectfully consider that Lord Justice Patten was entirely right in his analysis of how the Special Commissioners reached the decision they did on the facts of that case. There was no finding of usurpation in the sense described in Wood and Holden. We do not accept Mr. Rivett's submissions that the Special Commissioners were not rejecting the approach in Wood and Holden. They expressly rejected Wood and Holden. So whereas my learned friend said below that the Special Commissioners applied the right test and the Court of Appeal upheld that test, he now says that the Special Commissioners applied the wrong test and the Court of Appeal said nothing about the correct test. As I will seek to demonstrate, that is not correct. Can I turn please to the decision of the Special Commissioners and just start by highlighting one or two facts which in my submission help to elucidate and explain how the Special Commissioners reached their decision. So in the authorities bundle, can I please invite you to go to page 281. Just to look at two documents, please, and then I'll explain the relevance. So the first is that quoted at paragraph 21, a letter from Mr. Gadd, who was of KPMG Bristol, to Mr. Smallwood, who was a settlor, following up a discussion on tax savings. And the letter said, in essence, if the intention is to sell First Group shares during this tax year, the order of the transactions would be as follows. 1. Tier trustees, the first set of trustees, resign in favour of the trustees based in Mauritius, who can be partners in KPMG there. 2. The shares are sold. 3. UK resident trustees are appointed before the 5th of April. And then, so that was to Mr. Smallwood, and then to like effect, if I could ask you to go over the page to 282, please, and look at paragraph 27, which quotes an email from Mr. Turberville to Miss Taher. She was of the Mauritian trustees, and the email says, after taking council's opinion, it has been decided in principle that the Jersey trustee will resign in favour of the Mauritius trustees so that the trust becomes tax resident in Mauritius. Provided that the new trustees agree that it is sensible to sell, so it was provided that they do agree, they will do so at some time within the next 3 to 4 months. If they sell the shares before the 5th of April, they would then retire in favour of the UK resident trustees also before that date. If this course of action is followed, it's hoped that no UK tax liability will arise. So you can see that the steps that would be required to implement the round-the-world scheme were very clearly set out to the settlor and then to the trustees in advance of the appointment of the trustees. But it was premised on the fact that the trustees themselves would be taking that decision. So if they agreed, then these were the steps. And you can see in paragraph 28, the following paragraph, the last sentence, there was no stipulation that the shares had to be sold before the 5th of April, although it was clear from the email that there was a hope and confident expectation that the shares would be sold. And that label of confident expectation is important in this case. It was one that was picked up by the FTT in our case, and it was all of a piece with the settlor having put in place a scheme that the sole purpose of which was to sell shares. But it was no more than that confident expectation that the trustees in Mauritius would act in accordance with that desire of the settlor. And we have in our case similar documents setting out to the Mauritius trustees the steps that they would be required to take, albeit making clear to them that they would have to make those steps. Just for your note, my lord, you have paragraph 116 of the FTT decision on page 138 of the core bundle, sets out what I say is a similar email, but I don't invite you to print it unless you wish to do so. If I can ask you to go forward then please to page 288 of the bundle. Paragraph 61 describes the crucial telephone meeting in which the decision was made about whether to sell the shares. During the telephone meeting, Mr. Jingri reminded those present, Mr. Jingri was of the Mauritius trustees, that the trust had migrated to Mauritius within the context of a tax planning exercise and that the shares, if the trustees decided to sell them, had to be sold before the end of March. So again, it wasn't certain that they would be sold, but it was known when they would have to be sold, if they would then be sold. Then, skipping a line, as it was in the interest of the trust and the beneficiaries, the trustees thought it best to dispose of all the shares well before the end of the tax year. The price of the shares was also discussed. The meeting discussed the appointment of an investment manager. The meeting agreed to proceed with the sale of all First Group shares. We accept the evidence of Mr. Kuhn that the reason for the decision was because the sale was in the interest of the beneficiaries of the trust to maximise the trust fund by the proceeds not attracting tax in the UK. So the decision was made because it was in the interest of the beneficiaries. There was a decision made by the trustees on that date. Then, if I can move away from the facts, and we'll come back to them when we look at the actual decision reached, but if we can go, please, to the interpretation of the treaty that the Special Commissioners reached. We could start, please, at paragraph 94 on page 298 of the bundle. You've seen before that they there set out the guidance from Commerzbank, and of course you're aware, you see in subparagraph 5 on page 299 that includes the statement that subsequent commentaries on a conventional treaty have persuasive value only depending on the currency of their reason. And that is of course, the same summary that was subsequently adopted by the Court of Appeal in Smallwood. If I could ask you to then to go to paragraph 109, please, on page 303. You see here the different approaches of the parties, and as I've already alluded to, those different approaches were ones that were also put before the Court of Appeal. So paragraph 109, Mr. Prosser for the taxpayer contended that at the time of the treaty, the commentary recorded the UK's view that central management and control meant poem. He accepted it was legitimate to apply the current commentary. My learned friend doesn't, but it was common ground in this case that you could. And then, skipping 4 lines, although the statements of Lord Justice Chadwick and Wooden Holden, that it is clear that the place of CMC is different from poem. Sorry, it is not clear that they're different, and that in the context of a single transaction case, it is very difficult to see how the 2 tests could lead to a different answer are not binding. The same view should be adopted. The 2 tests for practical purposes are the same. And then at the last sentence of that paragraph, he relies on Wooden Holden in paragraph 27 for the distinction between directors being dictated to and people advising. And paragraph 110, the revenue contend that one should follow the words of the commentary. It was not the correct approach to ask where CMC is situated, and to say that poem must be in the same place on the basis of Lord Justice Chadwick's statement in Wooden Holden, and it was said effective management implies realistic positive management. And then you have the passages that my own friend showed you yesterday, where in 111 it is said that there was some debate about whether or not poem is different from CMC, but that the Special Commissioners consider misses the point, because the 2 concepts are entirely different. So, the 2 concepts serve entirely different purposes. CMC determines whether a company is resident in the UK or not. Poem is a tiebreaker, the purpose of which is to resolve cases of dual residence by determining in which of the 2 states it is to be found. CMC is essentially a one-country test. The purpose is not to decide where residence is situated, but whether or not it is situated in the UK. And then you have that passage where they say there's nothing impossible in finding CMC in 2 countries in spite of the word central. And then you have consideration of the cases, and that passage at the end citing Central Railway Thomson as understood in Bulock. And at this point, my Lord, if it's convenient, I'd like to turn to Bulock just to explain in a little more detail what the references are to Swedish Railway and Bulock. So you should find that in the authorities in which the additional tabs have been added. And I would invite you to go please to Bulock, which is at tab 9. Sorry, tab 8. I would invite you please to go to page 360, which is internal page 219 within your bundle. And just to be clear, Bulock was not itself a case actually about dual residence, but it makes some comments about the concept of dual residence. The other reason for going to this case, my Lord, is that to the extent that the court is concerned with the understanding of the UK and Mauritius in 1977 as regards the UK's domestic law on CMC, this at that stage would be a relatively recent statement of the House of Lords, and so it clarifies and confirms what the state of the law was on CMC at that date. And what it makes entirely clear is that the test for CMC was that set out in De Beers, and that is a test that focuses on the actuality and substance over form. So you see the endorsement of De Beers at the 2/3 of the way down this page. After the quotations, you have a passage, a sentence starting, "For it has been tried law for 2 generations." that a limited company resides for the purposes of income tax where its real business is carried on, and that its real business is carried on where the central management and control actually abides. This test has not only been reasserted and applied over and over again in judicial decisions, it has now been received legislative recognition, see section 46A of the Income Tax Act. It cannot be questioned by your lordships. The familiar words that I have cited come from Lord Lorrable's speech in De Beers. At that time, the possibility of an artificial person, such as a limited company residing in two countries at one and the same time, had not been fully examined. And then it said 20 years later, in Swedish Railway, Mr. Justice Rowlatt saw no difficulty in such a concept, and indeed found it easier for a corporation to have two residences than a natural person. And though in the same case in the Court of Appeal, Lord Justice Atkin, as he then was, said that he felt constrained by authority to come to a different conclusion, and in the House of Lords, Lord Atkinson, in a powerful dissenting speech, took the same view, and then this is a point confirming dual residence. It must now be regarded as clear law that an artificial person may, like a natural person, have more than one residence. Then if I could ask you to go down to page 363 of the report. There are passages here in which Viscount Simons focuses on the need to look at the actual facts of the case, right, the substance over the form. So in that first paragraph at the top of the page, the business is not the less managed in London because it ought to be managed in Kenya. Its residence is determined by the solid facts, not by the terms of its constitution, however imperative. And then if I can skip half a dozen lines at the right-hand side, there's a sentence, I come therefore to the conclusion, though truly no precedent can be found for such a case, that it is the actual place of management, not that place in which it ought to be managed, which fixes the residence of the company. If it were not so, the result to the revenue would be serious enough. In how many cases would a limited company register in a foreign country, prescribe by its articles that its business should be carried on by its directors meeting in that country, and then claim that its residence was in that country, though every act of importance was directed from the United Kingdom? So the purpose of Lord Lorrable's test, emphasising the facts of each case and substance over form, is to avoid the kind of artificiality that one would have if the test of residence were based upon constitutional documents and the like. And then, if I could invite...
Just pausing there. That last part, in a sense, Wood and Holden is a elaboration on this. It's trying to work out in what circumstances you do depart from the constitutional position in arriving at a conclusion as to CMC.
My Lord, I would say it's an application of the test to the particular facts of that case. And one of the notable facts of that case is there was very little for the company resident overseas to decide. That was not a case in which there was a series of transactions over a long period of time, but it's an application of this test.
An application perhaps reduces its significance, but anyway, leave that aside. It obviously is an important point that you can have two residences because you can have two CMCs. In what circumstances can that arise?
My Lord, a very simple example that might be suitable to the modern day is you could have two directors who are resident themselves in different countries, and they never meet for a board meeting. They conduct their board meetings over Teams or Zoom or the like. And the court would be required to say, where is CMC? And it would be likely to conclude that CMC was in both places. And if it was necessary to determine where the company was treaty resident, it would be necessary under this treaty to apply poem to determine. And you would be forced to look at facts to distinguish one over the other. You may look at the seniority of the director, or the decisions that are made, or how many of the decisions are made by one director or another. But the point is, you would be required to choose to reach the one poem, because that test, as my Lord Arnold said yesterday, does require you to reach a conclusion that there is only one poem, and you would look at all the facts of the case to determine it.
So just picking up, I think, a point that was made by Mr. Rivet yesterday, I think he was suggesting you would be only likely to have a dual residence case where there was a constitutional provision. You say not so. It can be a factual situation, such as your situation, your postulated case of the directors in different countries and not meeting.
Yes, Michael. And the special commissioners, obviously, they hypothesise the case of De Beers a bit further, but you have a number of directors in one country, you have a number of directors in another country. They are both performing CMC. So if you were to ask, was CMC of De Beers in South Africa at the time, the answer would be yes.
Yep.
It certainly could be yes. It would also be in London, or in the UK, I should say. And then you would be required to apply POEM to resolve that. My Lord, if I can invite you to go to the speech of Lord Ratcliffe, please, and that's at page 365. And you see just below where Lord Ratcliffe's name is on the report, so about 10 lines down. Since it has been common ground between the parties that a company may have more than one residence for the purposes of taxation, I do not think that the admission has any particular bearing, and that was the admission there was the admission that the companies were also residents in Kenya. And then you have...
But he then says that he wishes the admission had not been made.
He doesn't find them helpful to resolve that case. And as we'll see later, that's because in this case they weren't concerned with your residence.
No,
POEM wasn't an issue. The only issue was, are these companies residents in the UK? It didn't help to look at whether they were also residents in Kenya.
Yeah.
But you see in the following paragraph, about 8 lines down, 6 lines down, he talks about the development of the test of CMC. Towards the left-hand side, the sentence starting, I think that a statutory code could have been provided, and on the whole I regret that it has not. On the other hand, the necessity of establishing some common standard for the treatment of different taxpayers meant that the courts of law were bound in course of time to produce and apply some general principle of their own to form an acceptable test of residence. No doubt it might have taken a variety of forms. The country of incorporation, the site of general meetings, the site of meetings of the directors' board were all possible candidates for selection as the criterion. In fact, as we know, the principle was adopted that a company is resident where its central management and control abide. Words which, according to the decision of the House of Lords that finally propounded the test in De Beers, are equivalent to saying that a company's residence is where the real business is carried on. Again, the emphasis is on the real business. Then over the page, skipping the first sentence, but in the circumstances I believe that such a process to have been inevitable, and in my opinion the De Beers judgment, followed as it is by a number of other judgments of the highest authority which have accepted, and the same principle must be treated today as if the test which it laid down was as precise and unequivocal as a positive statutory injunction. That means there's no escape from Lord Orban's words. A company resides for purposes of income tax where its real business is carried on. I regard that as the true rule, and the real business is carried on where the central management and control actually abides. And then Lord Ratcliffe says, I do not know of any other test which has either been substituted for that of CMC or has been defined with sufficient precision to be regarded as an acceptable alternative to it. To me, at any rate, it seems impossible to read Lord Orban's words without seeing that he regarded the formula he was propounding as constituting the test of residence. If the conditions he postulated were present, there was residence. If there were not, other conditions did not suffice to make up residence. So again, it's emphasising that at this point in time, it was Lord Orban's words and the broad positive test, if I can put it that way, which was the test of residence. Certainly, you cannot see the reduction of a test as set out in paragraph 36 of my Learned Friends Strength and Argument as summarising the effect of CMC.
I mean, just talking around this for a moment, as you say, at the time when the Mauritian Treaty was concluded, Wood and Holden had not been decided. So you had the De Beers line of authority running through to the Bulock case, Now, in those circumstances, one might say, well, why wouldn't the United Kingdom have been happy with CMC as the relevant test for the purposes of the treaty?
My Lord, there are a couple of ways of answering that. In a sense, it is not so much would the UK have been happy. The court is concerned with the autonomous treaty interpretation within an OECD model, a treaty based on the OECD model convention. So, and we'll come on to it in due course, but of course the court is concerned with the intentions of the parties to this bilateral treaty at the time. But the context in which it is entered into is the OECD model treaty, which, as we'll see in some of the commentary in Vogel, it is an error for the courts in each jurisdiction to consider that its domestic test of residence somehow elucidates and explains the autonomous treaty test of Poland, because the whole point of the tiebreaker is to choose between domestic law tests.
And I follow that, but in that case, what's the significance of De Beers and Bulock and whatever?
Well, on that, can I help you? Because I've been reading on in Lord Radcliffe. He comes back to the two CMC's point at 368 to 369. At 368, just above the first poll punch, he says he thinks Swedish Central Railway is unfortunate. But then he goes on at the second poll punch to say he's of the opinion the best way of treating the matter as regards Swedish Central Railway and Egyptian Delta Land as one decision. And then much of the difficulty disappears. Bridging the pages, he says, Lord Sumner wished it to be understood that Swedish Central Railway Company's business and administration was such a nature that managing, controlling had to be done, were in fact done as much on English as on Swedish soil. He regarded the key of the earlier decision as being contained in the words of Lord Cave, and this is the quote that you put in your skeleton argument, that the company may have more than one residence. So whatever his uncomfortableness with Swedish Central Railway, he accepts the proposition that as a matter of law, you can have two CMCs. That's clear.
And there is, just before I come back to my Lord Justice Newey, I'm grateful to Lord Justice Arnold, there's a further statement on that point which is relevant. If I can invite you to go back up to 366. Where he says in the final paragraph, I'm able to perceive only two qualifications have since appeared which mar at all the simplicity and generality of the test. One is that the facts of individual cases have not always so arranged themselves as to make it possible to identify any one country as the seat for central management of control at all. Though such instances may be rare, the management of control may be divided, or even at any rate in theory, peripatetic. So that goes back to my example, Lord Justice Newey, of how you may have CMC divided. So tying that back, the UK domestic law test of CMC was designed to determine whether a company, or of course trustees, but well, in this case a company was resident in the UK. It is not effective as a tiebreaker between those two countries where CMC may be divided and CMC is in both places. And that, my lord, would explain why you can't use CMC at the tiebreaker level, having already used it first to determine residence in the first place.
So, I mean, I do follow that point. But on that basis, emphasising that the CMC test is about reality or whatever really doesn't come into it, does it?
My lord, the emphasis I place on those points is really a direct response to how the appeal has been put all the way up and how it's put in the skeleton argument by formulating a test which I say has a presumption and then rebuttable by way of usurpation or dictation. I say that is the antithesis of a positive test as elucidated in De Beers and now in Bulock, of looking at all the facts to determine, are the board actually involved in the decisions at all? It is a positive test to ask where CMC is. And
this is where I get confused, because you're emphasising the role of reality in the context of CMC.
Yes.
But you're also saying, well, CMC can't be the test. So what's the significance of emphasising reality in CMC when that's not your case?
Because the case that's put against me is that the only way of interpreting poem is the test set out in paragraph 36 of my learned friend's skeleton argument. And my point is, if the court were concerned with CMC at all, if you like, it's an alternative case, then certainly the test that is propounded by my learned friends is not the only interpretation of CMC, of poem.
I mean, can I separate the two things? I entirely follow you. You say, well, CMC is not the test, and it can't be because you need something that acts as a tiebreaker. That I understand. If, on the other hand, you say, well, as an alternative, CMC might be the test, then it's much harder to understand why Wood and Holden, which deals with CMC, wouldn't be in point.
Because Wood and Holden, by itself, does not summarise the test for CMC.
But it explains, in the CMC context, circumstances in which you do find that the decisions apparently taken by the constitutional body don't count. It's an exploration of where, in the CMC context, the constitutional role doesn't matter.
It is, my lord, but it obviously serves that purpose to help to understand the application of the CMC test. Maybe I'm making too much of this point, which is a more simple one, if you like, that it is that the test for CMC, is that stated in Lord Laurelburn, as you said in your judgment in development securities, the overarching principle is where it abides. And if you are seeking to set down a test for poem, it would not be the kind of formulaic test that you see in paragraph 36. It would be the type of positive test that requires consideration of all the relevant facts and circumstances to determine where a company actually abides, where its real business is carried on. That is how the CMC test is properly to be.
That's a much more far-reaching submission to suggest that in the context of CMC, you don't apply the Wood and Holden principles as approved in the Court of Appeal.
My lord, I don't mean to. I don't at all mean to say that you don't apply those principles. What I mean to say is that they do not give you the full answer to CMC.
Well, they deal with a particular type of situation which arises with CMC.
Yes.
And you're not, is it the case that you are suggesting that in the CMC context, Wood and Holden principles do not apply?
My lord, I can't say in this court that they don't apply, but they are not the whole story, as your judgment in development securities makes clear, my lord. Well, with respect.
When you say they're not the whole story, they're obviously not the whole story of CMC, but in the particular circumstance where Wood and Holden would operate, they do lay down, on the face of it, binding principles.
Yes, my lord. As an application of De Beers in particular circumstances, Wood and Holden lays down binding principles in this court for how that should be applied.
Yeah. So in a particular type of case, Wood and Holden explains how CMC operates.
Yes.
And surely your case is, well, we're not concerned with CMC. Not that that's wrong.
My case is that we are not concerned with CMC for those reasons, and I say it is. I maintain the submission, my lord, that the Wood and Holden, or a test that one could derive from Wood and Holden, does not accurately summarise the entirety of the CMC test, and it would not be appropriate to apply the test from paragraph 36, as being the only test to determine poem, and that is the case advanced by my learned friends.
Yeah. Now, can I finish nailing down two CMCs? At page 371, we see that Lord Goddard agrees with Lord Radcliffe. So as I see it, there is a majority of the House of Lords consisting of Simmons, Radcliffe and Goddard on that question. I've been skimming through Cohen and Keith, and so far as I've been able to discern, but please correct me if I'm wrong, neither of these two members of the House of Lords dealt with this question. But is that right? I mean, it doesn't matter because, as I see it, there's a majority anyway. Am I right? They don't really touch on the two CMCs point.
As far as I'm aware, that is correct, but I was just double checking about
Right.
Can I, the trouble with one of us being occupying your time, the other two do half listen and half look at, if the exercise is in part to determine what the two parties had in mind post the 1977 model, I've been looking at tab 24, which has got the model, then the commentary on it, and in particular page 651 of our bundle, which has got the commentary on Article 4.3. Yeah.
Yes.
And in paragraph 23, to which we were taken yesterday, we've got the caveat in the last sentence. That's the last 4 lines. Concerning conventions concluded by the UK, which provide that a company shall be regarded as resident in the state in which, quote, its business is managed and controlled, it's been made clear on the UK side that this expression means the effective management of the enterprise. So I read that as the UK then in 1977 saying that for Poem, CMC, the CMC approach is the approach to be adopted, whereas, as I understand your submission, it is that they weren't, or they shouldn't be regarded as having CMC as the yardstick for Poem when the Mauritian treaty was signed.
Quite. My Lord, I will address this now, and we'll see how the special commissioners
Right, well, perhaps
Smallwood. But thank you for going here. Essentially, my Lord, the way to understand these paragraphs is, as you see in paragraph 21, the first one is that the statement that it's rare in practice for a company to be subject to tax as resident in more than one state.
Yeah.
It's of course possible. It's interesting to say if one state attaches importance to the regulation, the other to the place of effective management. So it's clear that there are countries that are using place of effective management as their domestic test for that. So in the case of companies, special rules for the preference must be established. It would not be adequate to look at purely formal criteria, and therefore it attaches importance to the place where the company is actually managed. You see the reference to, let's say, sort of real world management. And then 23, in my submission, effectively explains the background, the history behind the adoption of the test of Poem, to echo a point made by Lord Justice Arnold yesterday. So it explains that a formula for the preference criteria appear in those sort of transport-related conventions. A number of conventions for the avoidance of double taxation on such income accord the taxing power of the state in which the place of management of the enterprise is situated. Other conventions attach importance to the place of effective management, others again to fiscal domicile of the operator. So what we're told is that looking internationally, there are various different criteria that one can adopt, one of which is place of effective management. And what it's saying is, historically, concerning conventions concluded by the UK, which provide that a company should be regarded as resident in the state in which its business is managed and controlled, it's being made clear that on the UK side, this expression means effective management. So, as the specials explain, conventions which determine the residences where the business is managed and controlled were not actually concerned with tiebreakers. They were concerned with where a company was resident. And there was no tiebreak between two different places. Now, it is saying that in those conventions, the UK understood that test, i.e. where business managed and controlled, to be the same as effective management. What it is not saying is the UK considers that where place of effective management is used as a tiebreaker, it should be interpreted as being where the company is centrally managed and controlled. So it is to reverse the order of the words to say that the UK is interpreting Poem to mean CMC, and as I say, it is also important, as the Special Commissioners of Smallwood recognise, to see that business managed control is not being used as a tiebreaker there.
Well, they don't use the CMC phrase itself there, but I was taken by your examples some short time ago now of directors in two different jurisdictions, and so it could be said that CMC existed in two jurisdictions. I think you then went on to say, well, if that was the case, and I thought you were saying you needed to determine the Poem, you'd have to drill down into the facts to see what the distinction was between those 2, so that you would break the tie. In that way, what's wrong with that as a test? So you're using the concept of the approach of CMC. Where's the action really happening? And if you've got 2 of them, you've got to then decide where's it really happening. You've got to determine, and so I'm quite taken by this paragraph 23 as being, first of all, importantly, a spotlight on what people had in their heads in 1977, and therefore when this treaty was done, but also as quite an attractive test that fits with the difficulties that we've got in trying to find a form of words to capture what's going on.
So, Manuel, as I say, this is not telling you how the UK interprets place for effective management as this tiebreaker. If you have to break the tie between those 2 companies with the directors, you have to determine their place of effective management. And the question for this court is, what does determining the place of effective management mean? And if you put it as you are going one step further and looking at all the facts to determine where it's really managed, that is effectively what the special commissioners are saying.
Yes.
They are looking at...
And you're at great pains to say it's not CMC, and it may be because from your side of this appeal, you perceive that there's an elephant trap in the shape of Wood and Holden, that if you say CMC, and we then say, well, CMC is limited to Wood and Holden, then you fail. But you're also at pains to submit a bit like a Venn diagram, that if you've got a Venn diagram of CMC, obviously Wood and Holden is part of that, because it's a pretty clear case. If you've got a finding of usurpation, then the management isn't in Mauritius in our case. But that doesn't mean that there isn't a control and management centre that isn't as clear as Wood and Holden, but nonetheless falls within the definition.
And also, to be clear, there are obviously going to be cases in which you would find CMC and POEM in the same place.
That'd be an easy case.
Yes, and there are a number of factual circumstances, because both tests are concerned with management and effective management and control. So clearly that may well be the case for a company, that they do resolve in the same way. So I don't want to there's too much emphasis on pushing away CMC.
I don't want to take any more time, but there's an attraction to what's said in paragraph 23 of this commentary, because it doesn't actually use the phrase CMC. It talks about effective management without all the label CMC might drag with it in terms of possibly being limited just to Wood and Holden.
And we'll see the special commissioners say, before they look at the commentary, they say, looking at the ordinary words of the treaty and its purpose and context, knowing that the purpose of 4.3 is to break those ties between two countries in which the company is resident, you are looking at the real effective management. That is the test that they propound, and that is really not dissimilar to how my lord has just elucidated there. It is, but the key learning is a POEM can look broader. I say that is the key learning that one gets from the Court of Appeal in Smallwood, in that, especially that one is not looking just at the particular decisions of the time, but is looking broader, and as a tiebreaker in that context, it is necessary to do that.
Thank you.
I don't intend to take more time on it, but I would just, and I know my Lord Justice Arnold has read ahead in Lord Ratcliffe's judgment, but I would just highlight it at 370. There are further passages which make clear the importance of looking at the actuality. At 370, you see at the top, the first proposition lays stress on the consideration that none of the many judicial pronouncements which have asserted control and management to be the test of residence was directed to such circumstances as the present, in which the company's own regulations conflict with what has been done. This no doubt is true, but I think it is a very large step to deduce from that such pronouncements, despite the unvarnished plainness of their language, can have no bearing on the issue before us. After all, the purport of all of them is to repeat that the question where control and management abide must be treated as one of fact or actuality, and here control and management in London remain a fact, despite the failure to adapt the company's answer.
Yes, and the top of the next page he comes back to Lord Loreburn and de Beers.
And just following that quotation from Lord Justice Arnold, there is a passage making clear that we're talking about the amount of work that the Revenue would have to do to actually look at the facts of the case rather than look just at the constitutional instruments. And certainly my learned friends say, well, their test in paragraph 36 has simplicity, but in its simplicity what it loses, in my submission, is the learning about the facts of each case being particularly important. I should also just add one point. My learned friend said, well, CMC is a wonderful test because it's so clear. We've got 100 years of authorities and everybody knows how it's to be applied. All I would say to that point is, if we look at the judgments in development securities of the other two judges, there was a clear disagreement between them, not on the outcome, but on how the outcome may have been resolved if there had been, for example, a respondent's notice, Lord Justice Newey thinking that there wasn't enough for usurpation, and Lord Justice Richards having no such concerns, and considering that the inevitable outcome was a decision made in the UK. It's just an example of how it's wrong to say, well, CMC is very simple and an easy test to apply. Just concluding this point, if I may, on dual residence, could I invite you to turn to my small bundle of documents handed up? In tab 2, I handed up the case of Layer State and the Commissioners.
Oh my God.
Sorry, my lord. As by way of example, rather than suggesting that it establishes any particular precedent, this was a decision of the Special Commissioners, the First Tier Tribunal, as it then was, with Judge Avery Jones and Berner deciding the case. As you see from the head note, the company was a company incorporated and resident in the Netherlands under Dutch law, and the important fact is one of the directors and the CEO was resident in the UK. Now, if I could just invite you to go, please, to paragraph 25, which you will find on page 53 of the bundle. Right at the bottom of 52, top of 53, you'll see that Mr. Baker, for the taxpayer, set out a list of what he said were all the decisions that were taken, the resolutions and the decisions entered into, and how they were taken outside of the UK. If I could then ask you to go to paragraph 27, you see setting out the law. Of course, this is on CMC, so the first issue the tribunal had to decide was CMC. They say that they can deal with it relatively briefly because it's clear what the test is from De Beers. And the following paragraph, there's no assumption that CMC must be found where the directors meet. So it's wrong to say that you start with the where is the board. Rather, it's entirely a question of fact where it is found. Where a company is managed by its directors in board meetings, it will normally be where the board meetings are held. But if the management is carried out outside of board meetings, one needs to ask who was managing the company by making high-level decisions and where, even where there is, this is contrary to the company's constitution. And the next paragraph highlights the word abides from Lord Loreburn's test, and it's not therefore confined to a consideration of particular actions of the company, such as signing documents, but rather you look at a more general overview of the course of business. And in paragraph 29, he draws the analogy which Lord Lorreburn had between individual residence and company residence. In both circumstances, you can be dual resident. For the facts of that case, which I don't need to concern...
Just pausing there. I mean, Wood and Holden deals with a different problem, doesn't it? It doesn't deal with the problem of where the constitutional organs of a company or whatever make their decisions. It deals with when you can say that the constitutional organs haven't made the decision at all, it's been made by somebody else.
Yes.
So we're not dealing with that here.
Well, the quotation, or the finding paragraph 27 is effectively that point, my lord, that one doesn't start with assuming that the decision is made by the board, the constitutional organs. One looks at where it is actually managed.
Well, but it's still a different problem. The Wood and Holden problem is when was a decision that should have been taken by the company taken by somebody else. This is where within the company was the decision taken.
On the facts of this case, my lord, there were periods where the gentleman was a director and periods where he wasn't. So we're looking at sets of facts where he was making decisions as a CEO and not as a director, where the board was not.
But as a CEO, he'd have powers. It's a different problem, isn't it, where you can say that the decision wasn't made by the company at all, it was made by somebody else.
That could be, I see that could be a different problem. But my lord, the purpose of going here, as well as to show you those passages, was to highlight that this was a case in which the conclusion was dual residence. Not because there was CMC in two countries, but because there was incorporation in the Netherlands and CMC in England. And you see then the application of the poem test. And if I could take you to those passages, they start at paragraph 46 on page 61 of the document. So this is a case in which the specials of the first tier has already applied CMC to determine that there is residence in the UK. What they don't do is then apply CMC again to determine place of effective management. You see in paragraph 46, it says that there is dual residence. It's therefore necessary to apply the tiebreaker in the Dutch treaty, of course, in the same words as we have in our treaty. And then what is said at 48, neither party disagreed with the Special Commissioner's approach to the interpretation of treaties generally and their decision on the interpretation of poem in Smallwood. And then the judges of the FTT set out paragraphs 111, 112 that you've looked at. And the judges emphasise, you see just below the quotation, the last sentence. So that is the sentence that reads, accordingly, having regard to the ordinary meaning of the words and their context and in light of their object and purpose, we approach the issue of poem as considering in which state the real management of the trustee qua trustee is found, and they adapt that to say the company. It's an illustration of how these judges, when looking at the special commissioners in Smallwood, at the stage of the reasoning, even before you get to the commentary, etc., had seen what one takes from the ordinary meaning of the words as the relevant test. And then they apply that test. There was disagreement in paragraph 49 as to the time that one looks at. And in paragraph 50, you can see the conclusions that they reach based on Mr. Bock, the English director's activities, that they were activities concerned with policy, strategic and management matters throughout the time he was a director, and also after he ceased to be a director, we found his activities constituted the real top-level management or the realistic positive management of the appellant, and Mr. Chapman's activities were limited to signing documents. So they've looked at the activities of the two directors in the two countries and decided Mr. Box in the UK is the more important. So they resolve the tie in favour of the UK. That is, it's nothing more than an illustration, but an illustration, my lord, of how in the real world one can have the test of CMC applied first to determine residence and then poem, as interpreted here by the FTT, to break that tie. And in my submission, my lord, that is precisely that is the correct interpretation of the poem test and how it should be applied.
And a reason for the problem of us all dancing around these words is that the word management appears in both CMC and poem. So you're looking on your submission at different grades of microscopic analysis of the management. There's a higher level view that might entertain two jurisdictions having CMC, and then in terms of management, you go to find the place of effective management, which might involve you drilling down further.
And most importantly, it requires looking at both jurisdictions, whereas the CMC test, as Lord Radcliffe said, it doesn't actually require you to look at
because you've got to have two jurisdictions to have a tie to break.
You are only concerned for CMC tests with, is there CMC in the UK?
Yes, and so that's the observation that was made in Smallwood. They said they're distinct things, although the word management appears in both.
Yes, they perform different functions.
Yeah.
So, my Lord, could we return to Smallwood? And I thought that was something of a deviation from my run through the decision, but I thought because we got to the point where they talk about Bulock and dual residence, it was appropriate to go there at that point. Return to page 303. Sorry, 304.
Sorry, where are we?
Sorry, the authorities bond on mine.
In the main authority.
Yes.
Back to Smallwood.
Back to Smallwood. My Lord, I diverted to Bulock from the end of paragraph 111. Then you see in paragraph 112, the specials explain why poem performs a different function. And importantly, the sixth line down, one must necessarily weigh up what happens in both states and according to the ordinary meaning to be given to the terms. And of course, so they were applying the correct starting point, decide on which state the place of effective management is found, and then they correctly use their knowledge of French, which was one of the official languages of the OECD model, to say that effective means effective, which connotes the real management. And so from looking just at the words of the treaty, they reached that conclusion at the end of 112, which we saw quoted there in their state.
Can I just say that I've forgotten the detail of these decisions or the context? During the period in Smallwood when you had the Mauritian trustee in place, to get into, maybe this is wrong. For poem to be an issue in Smallwood, there has to be deemed to be residents in this country.
So because the trustees, before the end of the tax year, the Mauritian trustees resigned.
So that's the point. So it's good enough for poem to be an issue that at some point in the tax year, the trust was resident in this country. There's no finding, and then it did not need to be any finding as to where CMC was during the Mauritian trust period.
CMC was not a concern. My learned friend addressed you on the word general administration within section 69 of the TCGA. For domestic purposes, when that's how you get the charge of tax in the UK, it's sufficient that at some point in the tax year, the general administration of the trust was carried on in the UK by trustees resident in the UK.
So we simply don't know. Nobody needed to decide where the CMC was during the Mauritian period.
Because we're looking at a trust and not a company, CMC simply wasn't an issue.
And just talking around it for a moment, suppose it had been a company. How would that have worked? You would then have had to determine whether the CMC of the company was in this country.
Yes, the residence test then would be, was CMC in the UK? If so, then you have dual residence. Because it doesn't work on the Mauritian. We don't know necessarily how the Mauritian side.
But you wouldn't get to poem unless the company had been resident in this country during that period.
During some period in the tax year.
During some period of the tax year
in this country.
Yes, I see. So again, it's just at some period of the tax year.
Yes. Because, my lord, section 2 imposes the charge to tax on capital gains throughout that have the gains you've made throughout the whole tax year, even if you're only resident for 1 day.
Yes.
Yep. And my lord, obviously there was the snapshot argument, which was how it was decided in the the High Court rejected in the Court of Appeal. And the argument there was, well, at the point of time of disposal, they're resident only in Mauritius, therefore you're not in a dual resident situation.
Yep.
But what Lord Justice Patton judgment with which the others agreed was that no, you can have consecutive periods of residence, and even if you only know that the UK can impose a charge to tax, if you like, using hindsight, that is fine, because the double taxation treaty doesn't interfere with the UK's domestic charging provisions, and that's a key principle that one gets from Smallwood. So then at 113, as you see the subheading, place of effective management of the authorities, you can see that there's just the one quotation taken from Wensleydale Settlement Trustees. There are not many cases in which the poem of a trustee has been decided. This was one of them, but you can see that all that the specials take from it is the focus on realistic, positive management. And then, as my learned friend now says, he said it differently below, looking through 115 and onwards, and concluding at 118, you can see that the special commissioners did not take any assistance from Wood and Holden or the approach of CMC. And what they say in 118 is that they didn't obtain much assistance from these authorities apart from realistic, positive management. Then they look at the commentary. As my own friend said, the 1977 commentary is quoted at 119, so they start with the commentary in place at the time of the treaty. Then they explain that at 120 they give an example, it's the Mauritius example, but an example of how the words business is managed and controlled were used in previous double taxation treaties. And then they explain at 121 what they think of the sentence in the commentary. They say the commentary at the time of the treaty was therefore saying that poem was a concept already used in treaties in connection with shipping and air transport, or in some countries as the domestic law and treaty definition of residence, and was the same as where the business was managed and controlled. And where the business was managed and controlled, the expression then used in the UK treaties. Such treaties have nothing to do with the meaning of poem as a type. And that's the key point I emphasised to my Lord Justice McFarlane. And they say in the last sentence, the most one can read into the passage is that if dual residence was caused by different levels of management in each country, then poem looked at the same level as management control. 122, they reference the fact that that sentence was deleted. My learned friend suggested that they were using impermissible knowledge of the development of the treaty, and it seemed to be suggested that this was a reliance on unilateral practice by the UK. My submission that it is not about unilateral practice. They are simply recording the history here of how one got from the 1977 version to the 2000 version. They certainly are not relying upon the deletion as being somehow relevant or important to their interpretation of the phrase poem. And they set out the 2000 commentary, and then they say 124, we see no reason why this approach should not be adopted. They say it's not significantly different from the earlier commentary, saying the poem was the same as the reference to management and control in the old UK treaties, which meant CMC or the top level of management. It is really aimed at a different situation that of different levels of corporate management, which is not relevant here. So again, my learned friend said that I must be saying that 2000 was a radical departure from 1977. I just adopt the words of the special commissioners. It's an evolution. It's a historical fact that the sentence was deleted, but it didn't fundamentally change the effect of the commentary. What one does get from the commentary, you see that the second sentence there is the one that is highlighted in the Court of Appeal. But you also see it said the place of effective management will ordinarily be the place where the most senior person or group of persons, for example the board, makes its decisions, the place where the actions to be taken by the entity as a whole are determined. However, no definite rule can be given, and all relevant facts and circumstances must be examined to determine the place of effective management. Again, it is emphasising again the substance over form, and suggesting that you can't reduce it down to a simple rule. And the commentary makes a point in the last sentence that an entity can have more than one place of management, but it can only have one place of effective management at any one time. So the words of the treaty demonstrate that it is necessary for poem to resolve into one place, as my Lord Justice Arnold recognised yesterday, and that is emphasised in the commentary in 2000 as well. And then, if I could scroll forward a couple of pages, you get to paragraph 130. And this is, as I submitted yesterday, this is really the conclusion of the test that the Special Commissioners identify for determining poem. Based on, as they say, the ordinary meaning of the words in their context in light of the object and purpose. And the approach we take to poem is to consider in which state the real top-level management or realistic positive management of the trustee or qua trustee is found. And then in 131 they say they turn to apply that test. And that, in my submission, is the correct test for poem, and in my submission that is the test that the FTT applied in this case. And there is no error of law in her doing so. Going back to the facts brief, if I may, you see at 132, we first find that there was no doubt that all the actions of PMIL, the Mauritius trustees, were carried out correctly and well documented. So they did their role properly. 133. Nevertheless, during the Mauritius period, the influence of Mr. Smallwood, who was a settlor and who alone had the power to appoint new trustees, and the guiding hands of Mr. Gadd and Mr. Turberville were evident throughout. Now, as we'll see that when we come to look at the application, the detailed findings of fact, but you can see in this approach to poem the influence of the parties in the UK is a relevant, important consideration. It is obviously not necessary on this application poem to decide that they usurped the functions in Mauritius, but it is relevant that they influenced what was going on in Mauritius. Then 135, they quote Mr. Turberville's evidence, and just below E, they say there was an expectation that the tax planning scheme would be followed through, but it was no more than an expectation, albeit a confident expectation. The Mauritius trustees could have decided not to sell the shares, and there would have been nothing that he or anyone could have done to make them sell them. So again, you see that the decision to sell,
pretty close to being on all fours with the facts of the present case.
and indeed so. So I can develop this further if needs be. But my own friend said it's not clear to see what test the FTT in this case was actually applying. In my submission, it is clear from his decision how it was guided by Smallwood, and one can see the factual similarity. And my lord, it is frankly not surprising, because this is just another iteration of the round the world scheme.
Yeah. And to be clear, here, I'm not sure that it necessarily stays the same later on, but for the Special Commissioner's purposes, they are focusing on the period when the Mauritian trustee was in place.
They are, and their decision at towards the end is about the Mauritian trustee, but having regard to what happened beforehand in terms of setting up the scheme with a confident expectation, and what happened at the end with the appointment of UK trustees. But their decision on where was poem is focused upon what we'll call the Mauritian period. And then there's another subheading, the relevant facts above 138. And in 138 you see description of the planning scheme which was devised. The last sentence is important. That made it clear that the confident expectation was that the shares would be sold before the 5th of April 2001. Again, it is important that the scheme was put in place with that confident expectation, but it was only confident expectation. They make this clear at 139. We accept the evidence of one of the Mauritian trustees that she did not understand the basis referred to in the email as to mean that the sale of the shares was a condition of PMIL to accept the appointment as trustee. Her evidence was that the trustees would wish to receive appropriate advice and recommendations. However, she accepted that eventually, as part of the tax planning exercises, the shares would be sold at some time. We accept the evidence of Mr. Gingery that there was no agreement that PMIL would behave in a certain way or make certain decisions as a quid pro quo for the introduction of the trust. Their duties as trustees were laid down in legislation, and the trustee and PMIL would act within the context of what it was allowed to do. We also accept the evidence of Mr. Gingery that the whole point of the tax planning exercise was to sell the shares and to realise the gain, and to avoid the tax on that gain. And again, my Lord McFarlane, that is precisely the circumstances of this case. The whole point of the scheme was to sell the shares whilst the trustees were resident in Mauritius and seek to avoid the UK capital gain. And then 140 is important because it is where they state their first conclusion, but also it's cited by Lord Justice Hughes. So we know that he approves of what, effectively, the analysis in 139, which leads to 140. The facts surrounding the appointment of PMIL lead us to the view that the real top-level management or realistic positive management of the trust remain in the UK. So they are there not looking at the decisions actually made at the relevant time. They are looking at the facts that lead up to it with their appointment as part of this scheme managed from the UK. And Lord Justice Hughes specifically endorses that as the correct question to ask. And then says, of course, they were entitled to answer it as they did. They go on, 141, the view is confirmed by subsequent events. And 142, they accept the evidence of Mr. Jingri that the sale of shares was motivated by the UK tax planning reasons, and of course that was the reason it was all put in place. The purpose of selling all the shares was to ensure that the tax planning which had been put in place worked to the best advantage of the trust. It was vital that all the shares were sold prior to the end of March to achieve this. The decision to sell all the shares was made in the hope that all the shares could be sold before the end of March. However, if it had not been in the interest of the beneficiaries and the trustees would not have sold the shares. So you see, and they talk about if the share price had dropped dramatically. Last four lines, we accept the evidence of Mr. Taha that the decision to sell all the shares was based upon tax planning and the need for the shares to be sold by a particular date. The fact that the share price had gone up was not the driver. So they still had that decision to make about the number of shares to sell and when. And then 143 expands that further. And where it's said the decision to sell the shares on that day was taken by the directors. So that decision was not usurped, it was taken by the directors, albeit in the context of a scheme in which there was a confident expectation that the shares would be sold. But it is explained at 143 that is a lower level management decision. So they're looking at the real effective top level management, and they say that remained in the UK. Because the realistic positive management, 3 lines from the bottom of 143, the decision to dispose of all the shares in a tax efficient way had already been and continued to be taken in the UK. Key decisions were made in the UK. And the decision in this case to implement a scheme to sell the shares, albeit subject to the caveats about what the market would do and would the flotation go ahead, the whole purpose of putting in place that scheme with the appointment of the Mauritius trustees was to sell the shares. And
Can I just divert for a moment? Suppose you had the Mauritian trustee in place for the whole tax year. Now, I think it would still be the case following the Special Commissioner's decision that they would have thought that if you got to a tie break, the place of effective management was the United Kingdom.
But my lord, you wouldn't get to a tie break.
Well, that's the question. Would you get
no,
to the tie break?
Because it's necessary for the scheme to work to get into the tiebreaker that they were resident in the UK for some part of the tax year.
And that's what I mean. Would it have been found that the CMC was in this country?
No question of CMC because we're looking at trustees. So you are looking, so whereas CMC is the relevant test to determine residence of a company, you're looking at section 69 for trustees and looking at the residence of a trust is dependent on the residence of the trustees.
Yes, all right.
So the mere...
All right, let me put it slightly differently. So suppose it had been a company.
Right.
Then I assume the Special Commissioner's reasoning on place of effective management would have been the same, effectively.
They would have had to have found that CMC was in the UK.
Well, that's the question. Had they got to the tie break, they would still have said, well, the place of effective management is the UK, presumably.
It's hypothetical to...
Yeah.
It's difficult to see what they would have decided if it was in Mauritius for whole tax year. If, for example, it was an offshore trust that had been established for a long period of time, it was a genuine sort of offshore trust, as opposed to being moved there for a particular purpose during the tax year, knowing that UK trustees were going to be appointed at the end. With respect, I can see why my lord has wanted to work the permutations through, but that would be the facts of a different case.
Yeah. Okay.
I mean, intrigued both, I think, in the Smallwood case and in our case, the scheme had the trusteeship moving back to the UK before the end of the tax year.
And that was an
And
absolutely
you've just said
necessary-
if it didn't, then there wouldn't be, if there was no residence in the UK during the tax year, there wouldn't be any poem to recite. Why was it important for the schemes to move back to the UK during the tax year? Because you would think that would not be something they would want to do.
because it was necessary to avoid the effect of Section 86
Right.
of the TCGA.
So,
So that was a, I don't know if
there's a tightrope to be.
Exactly. So they didn't want to be offshore completely with UK settlors
Yeah,
and
got that,
beneficiaries.
yeah.
It was in order to avoid that, it was necessary to have
Yeah.
a period of residence.
Yeah.
But that brought you into the tiebreaker.
Hence the artificiality of trustees, first in Jersey, then in Mauritius, then in the UK, all within the one tax year, which you might suggest rather gives the game away as to what's going on here.
My lord, that was fully appreciated by the FTT. That and it was never suggested this wasn't a tax avoidance scheme.
No.
And nowadays we'll be attacked on all other ways of doing it. It has a feel of a slightly historic, quite blatant tax avoidance of moving to Jersey for a few months, sell the shares and come back. But it was it is resolved by considering poem, and you see how the specials look, what they saw as being important in that, and why poem remained in the UK. And you have there 144, the fact that the tax planning exercise was completed with the appointment of the UK trustees, and then 145, their ultimate conclusion, which again is a passage endorsed by Lord Justice Hughes.
And in three paragraphs, 140, 143 and 145, they use precisely the same formulation, the real top-level management or the realistic positive management of the trust, and they must have deliberately made sure that they were using that, and they don't say CMC.
Quite.
It's a different thing.
And my lord has seen before this passage 130 and 131,
Yeah.
where they use
And as you've made the point already, Lord Justice Hughes expressly endorses 140 and 145.
quite. Can I turn to the Court of Appeal in Smallwood, my lord? As I said, there's no need to look at with respect to the judgment of the High Court of Mr. Justice Mann. If I could go, please, to page 346 in the authorities bundle. And this is, of course, the judgment of Lord Justice Patton. And just to highlight that, as we know, he cites the guidance in comments back on the interpretation of a treaty, including a passage about subsequent commentaries. And as you'll be aware, my lord, I am aware that it doesn't appear that there was any argument in the Court of Appeal about whether it was appropriate to rely on 2000. So there's no reasoned judgment as to why 2000 can be relied upon. But as we know, this particular citation of Commerzbank by Lord Justice Patton is subsequently cited by Lord Briggs in Fowler as an example of the legitimate use of subsequent commentaries. So whilst it is not part of the ratio of Lord Justice Patton or the court in this case, that it is appropriate to use the commentary, it is, I say, difficult for my learned friend in this court to say that it is inappropriate to use later commentaries.
Well, his argument, which you haven't yet squarely addressed, is that it's inappropriate because Mauritius was not a party to the OECD.
And that is an argument that I'll be coming to deal with. Right. But as I say, it is in my submission relevant that Lord Briggs in Fowler identifies the very passage in Smallwood. So, and my learned friend says it demonstrates that the decision is manifestly wrong, or just Arnold. But it's difficult to see how this case, this reliance on 2000 commentary, could be manifestly wrong when the very reliance is subsequently cited by Lord Briggs in Fowler.
Well, he makes the same point about Lord Briggs. He says that point wasn't taken there either.
Yeah, and true. Incidentally, another case involving a non-OECD country, in which later commentary is relied upon. But I'll come back to that in due course. although we are not concerned with snapshot, I would invite you to look at a couple of paragraphs where Lord Justice Patten explains why he rejects snapshot, because in my submission they are helpful to explain why CMC doesn't provide the answer. And because, of course, you'll recall that Lord Justice Hughes refers to snapshot, and he says, well, Wood and Holden would be to go back to snapshot. So it's useful to see what Lord Justice Patten says. If I could ask you to turn to 351 and read paragraph, in the interest of time, read paragraphs 37 and 38 yourself.
Yeah, we need to read on to 39 and 40 to see that the point is rejected.
And then at 43, if I may, on page 352, having considered some of Mr. Brennan's submissions, it said, I therefore accept Mr. Brennan's basic submission that the provisions of Article 13.4 are not to be read as incorporating a reference to the date of disposal. And then he says he's not persuaded by other submissions. But if we go down to 10 lines from the bottom, in the middle of the page, Article 4.3, as I've explained, is focused on liability for tax regardless of the period of residence under national law, which creates that liability. Looked at in this way, it becomes meaningless and impermissible to draw a distinction between consecutive and concurrent periods of residence. The DTA is concerned only with the possibility of a double tax charge on the same gain and not with the period of residence which gives rise to it. If that situation occurs, then Article 4.3 operates to resolve the matter as part of Article 13.4, which incorporates it. And that really explains the answer to my Lord Justice Newey's point about, it was sufficient that the trustees are in the UK at some point.
Yeah.
And then we see that, if I can then ask you to look at paragraph 46 on the next page. In summary, then, I reject the trustees' argument that Article 13.4 requires one to look no further than where the trustees were tax resident at the date of disposal, without regard to subsequent events. So you can look at the subsequent events. I would also add prior events. I also prefer the view of the Special Commissioner as the resident of a contracting state under Article 4.1 means chargeable to tax in that state on account of residence, and that for this purpose one has to take into account the tax treatment of the gain under the domestic legislation of both contracting states regardless of the period of residence, which gives rise to the liability. So that is repeating the same point, so in different words. And then we get to the nub of it with the section on poem at paragraph 48. Poem is not defined in DTA, but was interpreted by the Special Commissioners as meaning the place which is the centre of top-level management, i.e. where the key management and commercial decisions are actually made. There's reference to Vogel, there's reference to German case law, and it said the Special Commissioners took as their formulation of the test a passage from the 2000 commentary. And then 49 is important. Mr. Prosser accepts that this is the test to be applied, and that what has to be identified is the place where the real top-level management of the trustee, qua trustee, occurred, rather than the day-to-day administration of the trust. But, and then this is important bit, he submits that the top-level management of a company is usually carried out by its board of directors, unless it can be shown that the control of the company's affairs was effectively usurped and exercised by some third party, and the directors were content merely to rubber stamp the decisions which were taken. In this case, he says, no evidence or finding that KPMG Bristol or Mr. Smallwood dictated the
Can you
decisions.
help me to understand what on earth that submission means? Because it's, in its own terms, a submission about a company, but the facts of the case were not concerning a company. It was a trust. So, on the face of it, it's with all due respect to Mr. Prosser, a nonsensical submission.
I'd understood the paragraph to mean that he was drawing an analogy between the decision of Wood and Holden and the present case.
I've forgotten again. Is the trustee was a corporate body?
Yes.
So maybe he isn't drawing an analogy. He's saying where you're dealing with a corporate trustee, you apply the principle.
That may be another reading as well. You can see at the end of
Paragraph 50.
paragraph 50.
It quotes Mr. Prosser as referring it to the trustee again, PMIL.
The corporate trustee.
Yeah,
right,
so it's confusing.
As identified. So, as you see in paragraph 50, yes, it is an Edwards and Bairstow appeal, but again, it's important. Mr. Prosser contends it was not open to the special commissioners to find the poem was anywhere but in Mauritius at the relevant time, and to have reached a conclusion which they did on the evidence, the special commissioners must therefore have applied the wrong test, and that's because he said the test was one derived from Wood and Holden, as we've just seen in the previous paragraph.
But just coming back to the question, I mean, of course, it's correct that PML was a corporate trustee, but certainly when you look at the special commissioners, their focus is on the human beings, and one might have thought rightly so.
They were focused on where the real decisions, if you like, the real top level management decisions were being made and by whom, and of course they identify in particular the influence of the settlor in devising the scheme and putting it all in place on the advice of the advisors. So they are looking at who in this context realistically is taking those high level management decisions, and they conclude it is those individuals who are UK residents.
I'm just trying. I must admit, I realise now I haven't thought about this carefully enough. So you've got a corporate trustee. So the question is how far you can say that decisions made by the trustee were really made by somebody other than the corporate entities, the corporate decision makers.
If one is applying CMC, that and Wood and Holden, that would be the relevant question. One would assume that you start with, you have a corporate trustee in Mauritius, and this is how the case is put in paragraph 36. You have a corporate trustee in Mauritius during the Mauritius period, and it is said that the correct and the only way to apply poem is to ask, were the functions of that corporate trustee usurped or dictated?
Yeah.
And they say no. And that is effectively, albeit
So
just as Arnold said, it's not entirely clear whether he is focused on the corporate trustee, but the submission is effectively that, and we'll see it developed in due course, but effectively that relying on Lord Justice Chadwick and Wood and Holden, that the Mauritius trustee was taking it is said, real decisions. They were not usurped or dictated to, and therefore it was improper to find poem in the UK.
And this may relate very closely to Lord Justice Hughes saying, well, we're not concerned with this trustee, we're concerned with the continuing trustee. But I come back then to my hypothetical and unhelpful example. Suppose you had the Mauritian trustee, corporate trustee, in place for a whole year, then a CMC test would have been appropriate. Or not?
You are still, no, because the test for the residence of the trust would still be that in section 69. So you're looking at where the trustee is resident. You don't, just because you have a corporate trustee, you're not using CMC.
But if you're looking at where the trustee is relevant, then you're looking at where this corporate trustee is resident.
Yeah, but
and then why don't you apply a CMC test?
But maybe I've completely lost the plot here. But surely this is why we're applying poem in the first place. It's precisely because PMIL is resident in Mauritius, being a corporate trustee.
Yes.
The question is it's established it's also resident in the UK, and we're applying the tiebreaker. Have I missed something?
No, but you are into the tiebreaker because on the facts of the case, rather than Lord Justice Newey, that they were resident in the UK under Section 69.
I mean, it's straightforward where there is a UK trustee for part of the tax year.
I do.
Which there was.
Which there was. So now I'm just trying to understand, could you have a situation where you had a Mauritian trustee in place for the whole tax year, in the circumstances where, if you applied the tiebreaker, you would say the place of effective management is the UK, but nevertheless, you don't get that far because the CMC is always in Mauritius?
You would need to. Can I confirm the position over lunch? But because it's not, I haven't sort of considered the hypotheticals. But the starting point is you're looking at the residence under Section 69, and you're asking if the general administration of the trust and the trustees were they were resident in the UK. I can conceive that you could be using CMC to look at the residence of the corporate trustee in order to determine that matter. And then if you found that CMC was in the UK, the corporate trustee would be the UK, therefore the trust would be resident in the UK. And if the corporate trustee was also resident in Mauritius, then you would be into the tiebreaker.
And I follow that entirely. What would be a bit more taxing, to use an inappropriate word, would be the idea that you conclude that if you do get to the tiebreak, the place of effective management is here, but you don't get to it because the CMC is always in Mauritius.
And maybe on some, but maybe, and if the answer is that the CMC is in Mauritius, then you're not into the.
You don't get to the tiebreak,
and that's fine. In a sense, well, that is the right answer in the facts of that case. If you don't get to the tiebreaker, my own friend made a number of submissions yesterday, albeit relatively briefly, about the terror in the advisory industry if you were to uphold the Special Commissioner's decision and effectively say that was correct, the decision from Smallwood followed by the FTT in this case. He struggled then to identify fact patterns of French pharma companies in which this might be an issue. But this goes back to, I'll come on to it later, my lord, but if you have an offshore company which is probably managed offshore for the whole year and it's not incorporated in the UK and the CMC is not in the UK, you just don't get into these questions.
No.
And if you have an offshore trust, which is where the trustees are not in the UK for any part of the year, then you don't get into these questions.
No.
So it is only because this scheme is put in place with these artificial steps of moving the trustees to Mauritius and then bringing them back in the same year that you're into this difficult question.
Quite. And if I could just return to the point that's bugging me. In Smallwood, the argument would have been identical if it hadn't been Pierre Mael, a corporate trustee. It had been Ms. Taha and Mr. Jingri as individuals. The argument would have been identical.
Yeah. And that was, yes, my lord, so I had that in mind to say as well, that I think that is correct. One is looking at where the trustees were resident, and they could have been individual trustees. And the question would be what...
They were in Mauritius, just as Pierre Mael was in Mauritius.
Indeed. So you'd be
It would have
looking
been
at
the same argument.
where the effective management was taking place, what decisions they were taking, what was done in the UK, comparing the two, weighing the two as a special say and coming to your conclusion.
Yeah.
So it is certainly not dependent on the corporate identity. Paragraph 52, we're on page 355 of the authorities bundle. These are still in the submissions of Mr. Frost. Well, it's being recorded, Mr. Prosser, but then what is said 3 lines down in paragraph 52, those witnesses said that KPMG Bristol, which had recommended the use of the Round the World scheme to Mr. Smallwood, were acting purely as tax advisors and could not tell the trustees what to do. They were in contact with PMAL throughout the tax planning exercise, but in order to make sure that they were going on fitted with what was going on fitted within the exercise, there was a confident expectation that the scheme would be followed through, but no more than expectation PMAL could still have decided not to sell the share. So this is what is effectively relied upon by Mr. Prosser, that it was nothing more than a confident expectation. Then you have the citation and quotation from the decision of the Special Commissioners. And paragraph 54, please, on page 357. Right at the bottom of 357, Mr. Prosser said that none of these findings amounts to or includes one to the effect that KPMG or Mr. Smallwood dictated or usurped the decision of PMIL to implement the scheme by selling the shares. That's now common ground between the parties here. Although the sales took place in accordance with the scheme devised and recommended by KPMG, the decision to sell remained that of PMIL acting through its own directors. 58, please. Mr. Prosser submitted that on the findings of fact made by the special, the board of PMIL had itself taken the decisions necessary for the conduct of the company's business as trustee and therefore exercised effective management. He places particular reliance on the decision of the Court of Appeal in Wood and Holden. We saw that as effectively how he formulated the approach that should be taken. And then there's quote reference to that case. Paragraph 59, Lord Justice Patton is there saying, the importance of the case for present purposes lies in the analysis of Lord Justice Chadwick of what is capable of constituting management and control of a company by persons who are not its directors. And then you see the quotations in 26 and 27. The Special Commissioners said the Wood and Holden and the other authorities on residence did not ultimately assist on the question of where the poem of PMIL was situated.
I'm sorry, I'm still catching up. Going back to paragraph 58. This was where this point actually might have some more relevance, because if you look carefully at what Mr. Prosser's submission is recorded as being, on the findings of fact made by the Special Commissioners, the Board of PML had itself taken the decisions necessary for the conduct of the company's business as trustee and therefore exercised effective management. So it might be said that there's a sleight of hand here. It's a very skillful advocate's sleight of hand. But he is actually at this point focusing upon PML as a corporate body and talking about its general business and saying, well, its general business as a corporation is being conducted by the board in Mauritius. There's no usurpation and so on. Whereas one might say that's not the question. The question is not how, as a matter of generality, PMIL is managed. The question is, what's its role in this particular disposal?
Yes. But of course, Mr. Prosser was recorded as accepting that one is looking at the real top-level management, as I said earlier. Here he is effectively making the submission that was in Mauritius, because in this case it was a corporate trustee with a board. I would say it could be the same if there was the individual trustee. In this case there was a corporate trustee acting properly through a board, and he's saying it took the necessary decisions. Nobody had usurped those decisions or dictated those decisions, and therefore, if you apply the right test, which is the one from Wood and Holden, then poem couldn't have been in the UK. And that in paragraph 60, Lord Justice Patton recognises correctly that the specials did not apply Wood and Holden. And then 61 through to 63 are important if we may take them slowly. Although the purpose of the poem test is effectively to decide between two rival claims to tax based on residence, so they are to that extent agreeing with what the Special Commissioners have said, the terms of the test, as set out in paragraph 24 of the commentary quoted above, seem to me to lead inevitably to the question whether the effective decision by PMIL to implement the tax scheme and to sell the shares was taken by the board of directors of the company, albeit on the advice and at the request of KPMG Bristol, or whether the PMIL board effectively ceded any discretion in the matter to KPMG by agreeing to act in accordance with their instructions. Given that the directors of PMIL remained in place and exercised their powers as directors to effect the sale, the approach to the issue suggested by Lord Justice Chadwick and Wood and Holden must be the right test. So Lord Justice Patton is saying that there is a correct test for applying poem, and it must be the approach the one derives from Wood and Holden. The conclusion of the commissioners in paragraph 140 of their decision, that the key decisions were made in the UK. Again, so he's identifying paragraph 140 as important. In the UK, where the realistic positive management of the trust remained, is said to be based on the facts surrounding the appointment of PMIL. It is clear that they were appointed as part of a pre-existing scheme which involved choosing Mauritius as the situs of the trust because of its favourable treatment of capital gains. It is equally clear that PMIL accepted the trusteeship on the basis that the shares would be sold as part of the tax planning exercise and that the shares were indeed sold in accordance with the scheme. But the Special Commissioners also accepted Mr. Jingri's evidence that there was no agreement that PMIL would behave in a certain way or make certain decisions as a quid pro quo for the introduction of the trust, and that had the sale of the shares not been in the interest of the beneficiaries at the date, PMIL would not have agreed to sell. So he's again emphasising that there is no finding of usurpation. I find it difficult to accept that on the basis of these findings, the Special Commissioners could properly have concluded the poem of the trustees up to March 2001 lay in the UK rather than Mauritius. The findings made do not go beyond saying that PMIL accepted the advice of KPMG to proceed with and implement the scheme in the interest of beneficiaries, but they retained their right and duties as trustees to consider the matter at the time of alienation and did not, on the Special's finding, agree merely to act on the instructions which they received from KPMG. The function of the directors was not therefore usurped in the sense described in Wood and Holden, and therefore he would have allowed the appeal. So, two key points are: Lord Justice Patten accepted the submissions of Mr. Prosser that the appropriate test for poem was Wood and Holden. Yeah, and he accepted that because there was no finding of usurpation, the Special Commissioners were not able to reach the conclusion they did. Therefore, they must have erred in law and applied the wrong test. And then to Lord Justice Hughes, and I'll just identify a couple of points which are not contained within the short judgment of Lord Justice Hughes. Firstly, you do not see any endorsement of Wood and Holden as the test for poem. Far from it. There is no statement to the effect that the Special Commissioners were wrong to reject CMC and Wood and Holden as providing the correct test for poem. As we've seen, rather he endorses the test applied by the Special Commissioners as asking the correct question. He does not say that he disagrees with Lord Justice Patten's assessment that there were no findings of usurpation. And in my submission, where he differs from Lord Justice Patten is regarding the test that Lord Justice Patten said was the right test. The reference, I said, to the end of paragraph 61, Lord Justice Patten saying the Wood and Holden must be the right test. And that, of course, is effectively what my learned friends are saying to you in this case, that Wood and Holden must be the right test. And so, taking a step back, you're faced with a minority judgment that said Wood and Holden must be the right test. The majority reach a different conclusion, and my learned friend says that you should find the Wood and Holden is the right test. So looking at paragraph 65, this is dealing with a snapshot and agreeing with Lord Justice Patten. Paragraph 67, the Special Commission's conclusion on the issue was one of fact, and taxpayers can only succeed on Edwards and Bairstow grounds. And then 68 is important in showing the distinction between Lord Justice Hughes and Lord Justice Patten. If the question were the poem of the particular trust company trustee for the time being at the moment of disposal, namely PMAL, then it may be that the reasoning of Wood and Holden would justify the conclusion that the commissioners fell into this kind of error. So if you are asking a different question, then Wood and Holden may be the right test to apply. And I agree that their findings do not go so far as findings that the function of the PMIL were wholly usurped. And then he says what Wood and Holden reminds us about. But, at the start of 69, but it seems to me that to apply this reading to the present case is to ask the wrong question. Now, I fully appreciate that the reasoning is fairly brief, but what he is saying there is that to ask the Wood and Holden question is to apply that reasoning for Wood and Holden is to ask the wrong question and to return to the rejected snapshot. Because
you're probably just coming on to this. Why is it the wrong question? Is it because it's the wrong time frame?
because you are as he then says, because is to return to the rejected snapshot approach.
And
Because there were, at that time, for some period of months, there were Mauritius trustees in place. Mauritius and only Mauritius trustees in place. If you focus on those Mauritius trustees and say, was there usurpation or dictation, you are necessarily narrowing your focus down to that one country. You are not having regard to the two countries and what happened, the activities conducted in the two countries over a period of time, and weighing those activities to determine where the real top level effective management.
So come back to the point. We don't want to return to the snapshot approach. So we don't just look at the moment of disposal. So is it a time frame point that Lord Justice Hughes is making?
This, and you can see it is the fact that it focuses upon the Mauritius trustees. It starts with the Mauritius trustees and looks at usurpation, dictation for them. As you can see, what he says is this ignores section 69. So it is about the fact that it focuses on one set of trustees rather than continuing body,
Yep, so
which of course brings in a time element because the UK trustees were later. But it is important.
So he's making 2 points. First of all, the key point of distinction is you don't focus on the moment of disposal. That's snapshot and that's out. But then what he's saying is, furthermore, you've got to look at the role of the Mauritius trustee, not merely over the whole period that the Mauritius trustee is in place, but also in the wider context.
Yes, in the context of the management of this trust over a period of time, which encompasses what happens in Mauritius and what happens in the UK.
So can I just try taking it a step further? So indeed, there's an emphasis on it's not a snapshot, and we look at trustees as a continuing body. If we're looking at the trustees as a continuing body, well, they were previously Jersey trustees and then they become UK trustees. But that again suggests you're looking at a wider time frame.
Yes,
because otherwise, well, it doesn't really matter whether you're looking at the trustee as a continuing body or not, because during the period when it's the Mauritius trustee in place, it's the Mauritius trustee in place.
There is a time frame element, but the special commissioners I've already submitted did decide poem looking at the Mauritian period.
That's
that way.
The slight oddity of this.
So, but the main point of distinction is between a one-country test and a two-country test. So you are not just asking, did these people in Mauritius exercise CMC? To put it that way, you're not saying, did they actually make decisions or were they usurped? What you are saying is that during this period of time, there were different things going on. There were things happening in Mauritius. There were things happening in the UK. And also it was all in the context of a scheme which had been set up in the UK for the purpose of selling the shares. So you are looking at you're actually looking at the Mauritian period, but you are looking at, as the Special Commissioner said, the facts what happened in the two countries that are party to the treaty, and using poem as a tiebreaker to weigh up what happened in those two countries and determine where the real effective decisions were taken. And in this case, as the Special Commissioner said, the decision of Mr. Smallwood to enter into the scheme on advice of the UK advisors, and then the superintendent of that scheme throughout from the UK, they were actually the real effective decisions in this case. And that was why they were able to conclude that the poem was in the UK. Notwithstanding that there were things genuinely happening in Mauritius and happening properly, like the trust administration.
Nevertheless, there is a problem with Lord Justice Hughes's reasoning, and the problem can be seen in paragraph 70 in the fourth line. He says, I don't think it's possible to say they were entitled to find the poem of the trust was in the UK in the fiscal year in question. Of course, if you framed the question that way, it was never in dispute. It was never in dispute. The poem was in the UK in the fiscal year.
Some part of the fiscal.
It would be in dispute. The poem was in the It wasn't a dispute that residence was in the UK.
Oh, I see. Right. Yeah. Sorry. Okay. Thank you.
And then obviously we see, as I said, we've seen his focus on looking at the.
Yeah, sorry, just on the temporal, going back to the penultimate paragraph of Lord Justice Patton's judgment, 63, page 361. There's an indication of the time limit on his finding, the first line. I find it difficult to accept on the basis of these findings, special commissioners could properly have concluded the term of the trustees up to March 2001 lay in the UK, but that's the date before it moved. Yeah, he's deliberately, certainly at the end of the period, not looking beyond.
Because the special commissioners have decided it, looking at the Mauritian period.
Yeah.
So he is.
So that's no point there, actually.
But I mean, does that shed light on this temporal question that's been bothering Lord Justice Newey? And I think I'm slowly catching up, which is that is it right, therefore, that in this kind of case we're always dealing with consecutive periods of residence, and the question is where nevertheless is the single poem.
So in this type of round the world case, you are always dealing with consecutive residence.
Yeah.
Of course, poem can apply
to be sure, can apply to concurrent residence
as much as consecutive.
But in this type of case, it's always consecutive residence within the tax year.
Yes. And you have the, if you like, the oddity.
But nevertheless, there's and if one was designing a double tax treaty, one might theoretically say, well, okay, you just do it on a temporal basis. You could have different slices of taxability within the tax year, but that's not how it's done.
Exactly. So yes, you may well, in a different world, that could be the answer, so that you avoid double taxation by having.
Yeah. So country A can tax the first half of the year. Country B can tax for the second half of the year.
Exactly.
But that's not how it's done.
It's not how it's done, because Section 2 of the TCGA applies a charge to tax to all gains made in the year if you're a resident for a day. Yeah. And so that and that is, conceptually why you have this oddity. But what we've seen the passages in Lord Justice Patton's judgment explaining that the DTA doesn't interfere with our domestic charging provisions. So the DTA doesn't say the UK, although you normally charge based on a day in a fiscal year, you can only charge based on the day in which the trustees.
Well, exactly so. But that's what gives rise to the oddity, which has, I think, been troubling all of us at different points in the course of this hearing, which is that you're applying a tiebreaker in a situation where, in one sense, there is no tie to be broken, because it's consecutive residence. So it's not a situation of simultaneous residence in two different countries. It's consecutive residence within, and for material purposes, two countries within the tax year, but that's sufficient for the reasons that you've been explaining. And then you have to have a single poem for that reason.
And it's because, as you'll recall from Article 4.1, residence in a country is determined by various connecting factors, of which one is, it could be a place of management, or it could be other stated criteria. And in the UK, under your domestic law, because you are resident for a day, you are chargeable to tax on gains throughout the whole period. So therefore, throughout the whole fiscal tax year. So therefore, there is dual residence. Although my Lord says there, in one sense, there isn't a tie to be broken. It's because you are liable to tax throughout the whole year that there is that period of dual residence, and you need to resolve that.
And I absolutely follow this. So you can well have a case where at any point in time there is not dual residence, but if you look at the whole tax year, there is dual residence.
Yes.
And arguably that is the basis of Lord Justice Hughes' decision. He says, well, look, yes, if you were simply looking at a point in time, then Wood and Holden might apply, and you would say that the taxpayer wins. But the point is, you look at the whole tax year, and looking at the whole tax year, it was open to the special commissioners to decide that poem was in the UK.
Well, Lord, the key explanation for why in 69 he says that that's to apply the wrong reasoning is because he relies on Section 69 as a continuing body. And
that matters because in the course of the tax year, it isn't just the Mauritian trustee.
So,
and Lord Justice Patton didn't divide it down to just, well, it's this month and it's Mauritius, and so that's it.
He certainly did not, my lord. And you can see
he's accepting a poem
that key endorsement to those paragraphs 140, 145 was that they were entitled to look at what happened across looking at that wider period, because we know that they, as my Lord Justice Newey says, that there was that period of UK residence subsequently, but crucially, the factors that Lord Justice Hughes relies upon as 70 are factors that predate the Mauritian period, the devisement of the scheme, that occurred during the Mauritian period, the superintendence of the scheme, and, if you like, occur at the end of the Mauritian period with the resignation of the Mauritian trustees.
And one oddity here, I mean, I'm supposing that Lord Justice Hughes is really saying, well, what matters is that we're looking at the whole tax year, not a snapshot moment. And during the whole tax year, the trusteeship changes, blah, 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 blah. What's curious is that the special commissioners haven't really approached it that way. They've focused on the Mauritian period.
But as I say, having regard to
they had regard to other things, but
actually
they were asking themselves where the poem was during the Mauritian period.
Yes, that was their answer, but determining that question by looking at the context in which things happened during the Mauritian period.
And I quite see that, but then
in particular the preceding events.
Yes.
The Special Commissioner's decision doesn't quite match Lord Justice Hughes' upholding of it, because his seems to be looking at a slightly different question.
Well, my Lord, with my respectful submission, the only slight oddity in Lord Justice Hughes' judgment is the use of the word there, the fiscal year, but rather than just the Mauritian period. But they are asking, of course, in my submission, he endorses the specials test and what they looked at, which was where were the real top-level management decisions happening during this period of dual residence, and they were entitled, for the reasons he said, to find that resolved in the UK.
Now, you gave us a route map for your submissions
Oh, yes.
some time ago now. Have we now got to the point where you've made your submissions about Smallwood, and we're now moving on to going back to first principles?
My Lord,
measuring that up against the first principles and saying it comes to the same point. Is that where we are?
We are almost there, my Lord. I was going to deal in this context with the question about whether this decision is wrong because it relied on the 2000 comment.
I think we ought to let you move on, otherwise we'll not finish.
My Lord, this is at the heart of the case.
This has been a useful discussion. I'm not at all being critical, but we must keep an eye on the clock.
Quite. What I did have in mind, my Lord, is to show you the passages in the Upper Tribunal where they effectively concur with the analysis I've just given. But the court will have read those passages, and I don't think they will. We need to look at them. Can I say could I look at one matter first before we move too far away from Smallwood, and that is the treatment of Smallwood in the Court of Appeal and the Supreme Court in the judicial review. Could I please, though, look at that in the context of the Upper Tribunal decision, and look please at paragraph 126 where the relevant passages are cited. So it's the core, I have it in the core bundle, page 94.
Thank you.
And if I could look first at the quotation from Lady Rose's judgment before returning to that of Lord Justice Newey, and look at the whole, effectively, of what she has said, quoted there. So it's paragraph 24 of her judgment. Lord Justice Patton held the Special Commissioners did not support a conclusion that effective management of the trust took place in the UK. He adopted the test set out in Wood and Holden. so that the poem of the trust turned on whether the critical decisions of the Mauritian trustee company were taken by its board directors, albeit on the advice and at the request of KPMG, or whether that board had ceded any discretion in the matter to KPMG by agreeing to act in accordance with their instructions. So just pausing there, I say yes, as we've just seen, Lord Justice Patten said that Wood and Holden was the only correct test that could be applied. Lord Justice Patten did not accept applying that test. The special commissioners could properly have concluded the poem of the corporate trustee lay in the UK rather than Mauritius. The trustees' functions had not been usurped in the sense described in Wood and Holden. The special commissioners' conclusions were not ones which were open to them on the evidence or on the findings of fact which they made. He would have dismissed the appeal, and we've seen all of that. Lord Justice Patten was, however, in the minority on the poem. Lord Justice Hughes also prefaced his conclusions by reiterating that the special commissioner's findings on the issue of the poem was one of fact, so that Smallwoods could only succeed on Edwards and Bairstow grounds. He agreed that the special commissioner's findings did not go so far as to establish that the functions of the corporate trustee had been wholly usurped in the sense described in Wood and Holden. That's important. If that were the test, then there may well have been an Edwards and Bairstow error, but he held the test was the poem of the trustees as a single and continuous body of persons as distinct from any particular corporate trustee at any particular time, on the basis, he said, and that's quotation. And what the Upper Tribunal says is, it seems to us that Lady Rose was recognising Lord Justice Hughes was applying a different test to Lord Justice Patten. And in my submission, that is entirely correct. Clearly, the precise difference between the minority and majority wasn't an issue in the Supreme Court, but Lady Rose's brief analysis in these passages entirely echoes, in my submission, the submissions that I've made to you, and correctly analyses the distinction between the minority and majority, and recognises in particular that they were applying different tests. It wasn't just that they were disagreeing on the facts.
Yes.
So, addressing then the passages in my Lord Justice Newey's judgment and that of Lord Justice Gross, it is important to read paragraph 121 to provide the context. And my submission, the Upper Tribunal 121 was entirely right in explaining those passages. So if I could maybe invite you, the court, to read 121 to itself. And then invite you to, then there's the quotations, invite you to read then paragraph 125. It's with some trepidation that I submitted all of Justice Newey what he decided in that case. But in my submission, it is entirely correct, the analysis in the Upper Tribunal, which is that the focus of the passages that my learned friend relies upon are whether HMRC overstated the effect of the majority decision, whether it was effectively binding on other courts, or whether the effect was an Edwards and Bairstow decision. And the precise dispute between the majority and minority was not an issue in that case.
I'm not disagreeing, Mr. Stone.
Grateful. So in my submission, just before we leave Smallwood, just to make a couple of concluding remarks. It is obviously correct that the ultimate conclusion was that the specials were entitled to find the poems in the UK, but in my submission that is because they looked at the test that was applied and they specifically rejected the test of Wood and Holden that Mr. Prosser was advancing. and that rejection of the Wooden-Holden test is at the core of the majority's reasoning. Looked at another way, the majority could not have rejected the appeal if they had considered the Wooden-Holden was the right test to apply. They would have had to, on the findings of fact, reach the same conclusion as Lord Justice Patton. Now, my own friend made some submissions about the ratio decidendi in reference to Youngson. I don't want to take up the court's time. I'm sure it's a decision, a judgment which is familiar to the court, but I would just highlight a couple of points, if I may, to support the submission that this rejection of Wooden-Holden and the endorsement of the Special Commissioner's test was part of the necessary reasoning, part of the ratio decidendi of the Court of Appeal, such that it is therefore binding on this court. Could I invite you to go, please, in the authorities bundle to 459? Sorry, I should have said this is tab 16. My own friend showed you the judgment of Lord Justice Leggett. There were three judgments in the court, the leading judgment given by Lady Justice Nicola Davis. If I can pick it up at paragraph 21 at the bottom of 459, she quotes there from Cross and Harris. And she says in my view, the key words contained in the statement of Professor Cross are treated by the judge as a necessary step in reaching his conclusion. So she's focused on the orthodox view of looking at the necessary step. Looking at applying that test to the facts before her at paragraph 25, I say to the facts before her, to the case before her, she looks at the judgment of Lord Newberger and in the case that was said to be binding, and 5 lines down she says that it was a necessary and decisive step in explaining their conclusions that the appeal should be dismissed. As such, it represented the ratio decidendi of the case. So her view was that she was obviously applying a test of necessary and decisive step in order to identify what the ratio decidendi was. And then looking at another, at the bottom of 461, she quotes from a majority decision in Whiston at paragraph 28 and says that it's been affirmed, and she says over the page, the affirmation was not overturned, it formed a critical part of the court's reasoning. So again, she is focused upon the question of what was the critical or decisive or necessary step in the reasoning. And then paragraph 34, please, which is on page 463. He says, I listened to and read the submissions of the parties as to the definition and reach of the concept of ratio decidendi. Interesting and well made as the submissions were, and then she agrees going at the bottom of that paragraph, I do not consider it necessary to further examine any conflicting theories as to the meaning of the ratio decidendi. This court is bound by Whiston and the later authority of Brown. And then you have Lord Justice Haddon Cave at paragraph 39, who agrees with the judgment of Nicola Davies. And if I could just invite the court to read that to itself. And as you see at the end, he says that the well-known and time-honoured statement of Professor Cross was sufficient to determine this matter, and in my submission, the same is true of our case. It was a necessary step in the reasoning of the majority to reject the Wooden-Holden approach and to endorse the approach of the Special Commissioners, because the correct approach to determining poem was squarely an issue in that case. And as I say, that case could not have been decided if they had not rejected the submissions of Mr. Prosser. We then have the passages that my learned friend referred you to and relied upon. If I could take you, just jump into paragraph 51, please, which is on page 468. Where you see in the third line down, it therefore seems to me that when the ratio decidendi is described as a ruling or reason which is treated as necessary for the decision, this cannot mean logically or causally necessary. Rather, such statements must, I think, be understood more broadly as indicating that the ratio is or is regarded by the judge as being part of the best or preferred justification for the conclusion reached. It is necessary in the sense that justification for that conclusion would be, if not altogether lacking, then at any rate weaker if a different rule were adopted. And my submission, what you have in the present case, albeit it's a brief judgment of Lord Justice Hughes, is you do have that the best or preferred justification for the outcome of the case is the rejection of the case put based on Wooden-Holden on the other side. And then I would just say, my learned friend took you to paragraphs 58 and 59, which, and at the start of 58, Lord Justice Leggett makes clear that generally the inquiry will start and end with looking at the rulings or reasonings given in judgment to justify the court's decision read in light of the facts of the case and the issues that arose. And my submission, that is on this case where the inquiry starts and ends. He goes on to say there's scope for argument about that a ruling or rule stated in the present case was framed too broadly, or decision is for some other reason better explained on a different basis. In my submission, we're not within those exceptions to the general rule, and it is sufficient to base ourselves on the statement of Professor Cross, which is cited above. And I would emphasise, if necessary, looking at the context of the decision, that albeit that the majority judgment is obviously shortly reasoned, in my submission, where you properly understand the context of the Special Commission's decision and the context of the submissions that were accepted by Lord Justice Patten, it was possible for Lord Justice Hughes to deal with the matter briefly, but one does get, from a proper understanding of the case, the disagreement over the test, and rather than just saying it's a matter of fact. And as much as my learned friend says, well, the test for poem wasn't an issue, clearly the correct approach to determining poem was squarely an issue in that case.
If it was just on the facts, then Lord Justice Hughes wouldn't have needed to refer to the statute and quote it in full.
Quite. And he would not have referred to Wooden-Holden and effectively, which was the test that Lord Justice Patten referred to, and explained why it's not the correct approach in this case.
He distinguishes it.
Yeah. Quite so. And so it is far too narrow to say that just because the parties were agreed that the commentary was sort of the correct overarching test, the test wasn't an issue. The approach to determining poem was squarely in issue, and was put squarely in issue by the submissions on behalf of the taxpayer. I was going to say briefly that it being binding on you, the judgment of the Supreme Court is, the Court of Appeal in Smallwood is neither per curiam nor, if there is a residual category, that it contains a manifest or error. As much as my learned friend didn't abandon the per curiam point, he clearly was not able to identify any binding authority or inconsistent statutory provision which had been ignored or forgotten in the Court of Appeal in Smallwood. The OECD commentary is, of course, not binding. It is persuasive. Persuasive only, even the commentary that predated the date of the treaty. And to the extent that there is a residual category of cases which are not per curiam, but the Court of Appeal will not follow its previous decisions, they have been described as the rare and exceptional cases, and the better course is to allow permission to appeal to the Supreme Court. So I don't intend to take the authorities on those points unless
No. Thank you.
But then that does lead me on to one argument which was advanced, or Justice Arnold referred to, which is about whether the judgment was effectively wrong because the Court of Appeal referred to the later commentary, the 2000 rather than 1977 commentary. In my submission, it starts from from reading too much into the 1977 commentary. You have my submissions already on that point, that it was effectively recording an historical fact about how the UK approached not a tiebreaker test, but a test of central management and control, rather than setting out the interpretation of the tiebreaker component. But the key question is there a rule that commentaries post-dating a treaty cannot be relied upon?
No, that's not the argument. It's not simply a question of post-dating. The argument is, and they weren't a party.
So, the way I was going to approach it is to make good the point that post-dating commentaries can be relied upon, and then address the arguments. Is it different for non-OECD countries? Just before I do, I just make one point. My learned Lord Justice Arnold referred to being a party. My learned friend referred to the OECD model as a multilateral treaty. It isn't. There is no binding international instrument in the sense of a multilateral treaty. There is a model. There is an international organisation, which the OECD is. It clearly does a lot more than just issue guidance on tax matters. Whether a country decides to be a member of that of the OECD may involve lots of different questions, but one of the things it does is to seek to aid multilateral trade and cooperation between countries in matters of tax, and so that is the correct context to consider this. Just to square off the point that subsequent commentaries can be relied upon, I've already referred to Lord Briggs in Fowler, paragraph 18. I don't need to take you to it unless you wish me to, where he specifically refers to the judgment of the Court of Appeal in Smallwood.
Well, I think you've covered that ground earlier.
And I'll just add to that the judgment of Lady Rose, which I'll probably return to after lunch in Royal Bank of Canada, where she refers specifically to Fowler and accepts that later commentary can be relevant, and in that case, the court applied later commentary, so commentary post-dating.
Well, I mean, it's one of these questions of, as always, what is the status being recorded to the document in question? Because if you recorded the same status as academic commentary, then the fact that it post-dates can't possibly be an objection, because of course academic commentary will almost always post-date. But if, on the other hand, you treated it as having some greater status, then the position might be different.
So, my Lord, as I understand my learned friend's submissions, and certainly I would characterise them in this way, he must have to say to you that it was inadmissible to have reference to them at all. So they were simply not a source that could be looked at all for interpretation. Because if one looks at the Special Commissioner's decision in Smallwood, as I've said a moment on a number of occasions, they did not place excessive weight on the commentary. In fact, they reached a conclusion of the test at paragraph 113 before they'd even looked at the commentary. Then they look at Wensleydale and they add the words realistic positive management. And to the extent they take anything from the commentary, it barely adjusted the test at all. So this is not, so unless my learned friend can show you that there is a black and white rule that later commentary for non-OECD countries cannot be relied upon, then in my submission this submission doesn't assist him. And it is noticeable that he hasn't shown you any authority for the proposition or any commentary on the point that that later commentary for an non-OECD member country is inadmissible. Having heard the submission, and I hadn't recognised the submission before yesterday, we did try in the time available to identify any cases in which the court had to determine whether it is permissible to rely on later commentary for a non-OECD member country. I'm afraid we drew a blank on that. What we did identify are a number of cases in which courts have applied later commentary to treaties with non-OECD member countries, and two of them are handed up to you. But I don't in a sense, I don't require you or invite you to turn them up. They are handed up because I was going to make reference to them in case my learned friend wanted to say anything about them. But the two decisions there are a decision of the Upper Tribunal, in a case called Davies, which was concerned with the very Mauritius Treaty, which is before you. And in that case, later commentary was relied upon. And the other case is the case of Indo-Food, which you'll recall the special commissioners look at in Smallwood. And in that case, bizarrely, the court was concerned with how an Indonesian court would interpret the Indonesian-Dutch treaty, and Indonesia was not, and it's not a member of the OECD. And again, the court was using as an aid post-dating commentary.
Just talking around it a moment, I mean, supposing you had an academic article which put forward a cogent argument, plainly you wouldn't say, oh look, that's irrelevant because the academic wasn't a party to the relevant statute, treaty, whatever. So if you are only taking into account later commentary for its cogency in the same way that you would an academic article, it's hard to see how there can be an objection to that, I think. Do you say that any greater significance can or should be attached beyond that of an academic article? You judge it by its cogency?
No, my lord, I don't seek to place any greater weight on it than that.
Yep.
And that is the guidance we get from Fowler and Royal Bank of Canada, that later commentary is persuasive as determined by the cogency of the reasoning. And I say that the same would be the case for a non-OECD member, or treaty with a non-OECD member country. And so I referenced Davies, I referenced Indo-Food, and just to repeat, of course, Fowler itself was with a treaty with a non-OECD member country, and Lord Briggs said that it was, and the Supreme Court did refer to and apply post-dating commentary. And if it were entirely inadmissible to look at later commentary, you would have this tantalising prospect, to refer to the expression from yesterday, of treaties with OECD countries, sort of ambulatory treaties, where as long as the consensus moves over time and it evolves, it doesn't sort of dramatically change, or is not materially inconsistent with previous.
But the way of working
that you can
it.
continue to refer to it.
But
That's the way.
This is the point, isn't it? Because it depends on what one's looking at. Is something that is simply cogent in its analysis, like academic commentary, or whether one's trying to bring it in as evidence of state practice, so as to be germane under the Vienna Convention. And as I understand it, you are not saying this is evidence of state practice so as to make it admissible.
I my learned friend say exactly in answer to Lord Justice Arnold's point that this is nothing about state practice. Yeah. This is about looking at the commentaries produced by the OECD in circumstances where Mauritius has signed up to a treaty based on the OECD model. They have. It's not an amendment. They haven't chosen different words. They've chosen precisely the words that are in the OECD model, and the OECD commentary provides assistance to domestic courts in interpreting those words. And I say, if it were not the case, then you would be left with ambulatory treaties with OECD countries, and none.
Wait, as soon as you say that, you're sliding into state practice. I think you have to be a bit careful.
Fine. Well, I don't rely on going there, then, but
did the later commentary say anything cogent that should be taken into account?
So the later commentary, as you'll recall, we may look at it again after lunch, but the 2000 commentary for the first time provided some guidance on.
But guidance can't be cogent exposition of what has already happened.
As the Special Commission said in Smallwood, looking at that 2000 commentary, it in fact was not materially different from the previous commentary. And that I think is maybe the crux of the point. That if we were seeking to rely on later commentary, which either related to a different article or was in completely different terms from what had been there previously, then there may be impermissible. But it is not contrary to what was said in 1977, and it is, as I say, we do not rely upon the deletion of a sentence from the 77 commentary as reflecting UK practice. The final point I'll make just before lunch then is to repeat the submission that the special commissioners place in fact very little weight on it, because they derived the meaning of the treaty article from the ordinary meaning of the words in its proper context. So my lord, that brings me to lunch. I do have some further submissions to make on treaty interpretation, but obviously I've done a lot of the heavy lifting there.
Good. And in terms of timing, how long do you think you will be after lunch?
I anticipate stopping at something like between 3 and 3:15.
Right. Mr. Rivet, that will leave you sufficient time, Mr. Rivet, will it?
My lord, I will have to make it, so...
Yes, but I think we will have to make it. It would be very difficult to come back. And
My learned friend indicated he would like between an hour and a half for reply, and hopefully if it between 3 and 3:15 leaves him there.
Good. Right. Promptly 2 o'clock. Thank you.